We are audible plus I think you can see the video, right?
Yes.
Okay, great.
So I'd like to just cue Man to introduce you guys and then we can begin.
Sure.
Good afternoon, everyone. So today's session will be conducted by Ankita Paul and Aakash Raman Sinha. Ma'am is a senior associate at Singhania Company. She is a member of Kolkata Bar Association. She has been handling all types of corporate law, advisory, and corporate litigation, IP, foreign investment, insolvency process, agreement drafting and vetting, M&A restructuring opinion, drafting, company registration, general legal advice. Aakash Raman Sinha sir is also an associate at Singhania and Company and handles civil, corporate, and intellectual property matters. He has been appeared before High Court of Karnataka, district courts, NCLT, and other tribunals. So I hand over you the session.
Thank you so much, ma'am. We are here to explain actually the topics on what are the legal aspects we should discuss and we should consider while hiring the first employee. So obviously hiring an employee is, it actually defines a company as a whole. So a lot of consideration, a lot of inputs has to be invested while hiring an employee, be it first or later also. So the first basic step of hiring an employee would be a background check and cross-checking with the references that proposed employee is sharing with the employer. So this is a very key aspect which Aakash will be explaining you detail later on. But the main topic of this discussion is employment related aspects, the legal aspects, where we come to the employment agreement here. So an employment agreement, it is a contract which will define the terms of an employee with like the association with the employee with the organization. So here what should be like the main topics which we need to drafting an employment agreement are basically the confidentiality. Then there will be indemnity. Then there will be a restrictive clause. What should be the term, termination, and remuneration, and other terms and condition. So I'll explain each of these topics in brief. So first of all, let's talk about what should be the basic components of an employment agreement. First basic component would be the name and identification of the employee as a whole and the employer too. So there is a name clause, then there would be a specific appointment clause. Appointment means it will refer to the company, that employee's date of joining, and it will give a definitive, mark on when this employee is being associated with the company for the purpose of remuneration, for the purpose of determining what's his or her terms and condition, job profile is, what are his or her deliverable are, all those points. So this is with respect to appointment. Let's come to the location. So obviously we know that any employee might subject to a permanent location or might be subjected to transfer. If it's a transferable job, then that should be clearly stated out in the employment agreement. Now, the second aspect we are handling here is the specific roles to be performed. So the employment agreement needs to lay down the specific job roles the employee is supposed to perform, be it in form of an annexure, be it in form of a separate job, JD you are referring in the employment agreement, but the job description and the role has to be clearly laid down, because it will help to determine what the employee is expected to perform in the organization. Next is the remuneration aspect. Remuneration has a lot of components which Aakash will explain you, but remuneration should be clearly stated or stipulated in the employment agreement. So remuneration will determine that this person, actually any agreement to be a valid agreement has to have a consideration clause. So this is a consideration, like in exchange of the services or the employment, the role he is performing or giving to the organization. This is the remuneration that they are being paid. So the components of the remuneration will be discussed by Aakash. And next is the working hours and leave policies and the vacations and all those aspects. So the working hours, leave policies, vacations, all these points come under the respective states Shops and Establishments Act. Again, Aakash will be discussing this in a later part of this session. Then now we are discussing, which is very important for the best interest of the company, are these clauses, the following clauses. That is indemnity. Indemnity is expected to be inserted in any agreement. So now as we are discussing about the employees aspect, so why it is an important clause? Indemnity clause actually protects the company from any kind of loss it is or damages the company is subjected to due to that employee. An employee is supposed to perform. So we already explained why the job description is important, right? So if the person is violating its job or the role which is being given, or it acts beyond the prescribed manner, so then a company might be subjected to certain damages. So for example, if the employee disclose certain confidential information of the company, which is privy to the company, due to which the company has suffered a huge loss. So this particular indemnity clause will protect the company in such an event. So how they will protect is like, in such damages, losses incurred by the company due to such breaches committed by the employee will be covered, as they have to make good of those losses caused due to such breach. So the indemnity clause protect company in such an event. Next is intellectual property. Intellectual property is considered one of the key ingredient in an employment agreement. So when you are giving an employee certain job role to perform, which might end the employee developing certain invention, be it patentable, non-patentable, some creation, be it copyrightable, not copyrightable, or protection under any intellectual property law. So who owns that particular? The employee is developing a particular IP product. So who is supposed to have the ownership of that product? So in this case, this clause will determine who is supposed to have the ownership. So basically, if I am this employee is creating some IP product, which is protected under the IP clause, laws under India, then that particular work is, subjected to, is actually basically called a work made for hire. It is the term which we use is work made for hire, means the employer is giving pay to the employee for such kind of work. But again, here there is a very thin line here to determine which is a work made for hire and which is not. For say an employee who is supposed to do a software development job in a company. Now that employee is working, given the parameters, what the job description is, he's been working. But with that kind of learning or skill set, he develops a software or a gaming software, which is not the requirement of the organization, but he did it out of the purview of the given job description. Then will the company have an IP protection over that gaming software? It's no. The answer is no, because that gaming software does not fall under the ambit of the given job description or role which he's being bestowed with. It is beyond the given purview. So in this case, the employee who developed the software, the gaming software, will have absolute protection. But now, in the other hand, if an employee is creating a patent, a process patent or product patent, is inventing a product which is patentable, and that is again by performing the job description which has been agreed to, then the company will have absolute right over that patentable, that product which is being invented by the employee. So this is the reason why indemnity clause is very much mandatory in order to determine who owns what in what situations. Next is confidentiality. I have to explain it in details, this clause, because there are a lot of litigation, a lot of cases happening because of this particular clause, which is not being well drafted. Any employment agreement should have a very sound confidential clause. Now, it can be a part of the main agreement, or it can be a separate agreement in form of a non-disclosure clause, NDA, which we say. So in the confidentiality clause, what are the key ingredients? We have to identify which information is termed as confidential information, first thing first. Next, we have to identify which information does not fall within the definition of a confidential information as per this agreement. Next thing, if there is a disclosure happening of this information without the permission of an employer, what are the repercussions the company is going to face? If an employee is supposed to disclose that particular information, then what should be the prior approvals required from the employer in order to disclose? So all these parameters have to be laid down to make a sound confidential clause or a separate non-disclosure agreement. This is a must-have in any employment agreement in order to protect the best interest of any organization. In absence of this, any company cannot monitor its own confidentiality, its trade secrets, its clients list, its data, anything. So if there is a breach, you cannot claim any damages, you cannot claim any protection, or if the matter goes to the judiciary, then it will be totally upon them to determine whether the information was confidential or not, whether to best. But if it is, we should already capture it in the agreement in the first stage itself. Let's come to the next thing, is termination. Termination, obviously, every agreement needs to have a proper term and termination. In employment agreement, we keep the term as an open. So we keep it as like if it's terminated otherwise. A termination can be by way of resignation by the employee or by the company. So if the person is resigning, he has to serve certain notice period. We need to stipulate down what is the notice period to be provided by the employee in order to terminate. Next thing is with respect to termination by the organization. So the organization in certain cases can terminate without any reason. They can ask the employee to leave, but obviously in such cases, it has to be governed by, like, there has to be a proper notice to be given, or salary in lieu of the notice period has to be provided. And all these relationship between the severance terms should be dealt as per Industrial Disputes Act, because an employer and employee's relationship is governed by the Industrial Disputes Act. It's considered to be the holy grail of all the labor issues which we handle. So if there is a breach committed by the employee, which the employee fails to rectify, and the company faces huge loss, or it does not face a huge loss, or whatever it is, the company may terminate for such breach. It can be in form of harassment, in form of a financial misappropriation, whatever be the reason. The company may provide a notice to the employee, to like a kind of a show cause notice, to explain his behavior or her behavior. If the employee's response is not acceptable, or if the company feels that this cannot be continued, this employment, then there should be terminated. That particular employee should be terminated. So these all terms should be defined very clearly in the termination clause, which should comprise of the notice period also. Next we are coming to the dispute resolution clause. So dispute resolution clause is like, in the event a dispute arising between an employer and an employee, what should be the methodology to resolve that dispute? In this case, methodology we generally adopt is either by way of referring to any higher officials in the company, involve the CEOs or any higher management, any director or HRs, to resolve the disputes between the employer or employee, or between any two employees, whatever it is. But there has to be a sound dispute resolution mechanism. Apart from that, if that mechanism fails, if the company fails to redress the grievances of that employee, then it will be referred to, we generally keep it as an arbitration clause. Arbitration is an out of court resolution method which we use, and that is generally adopted in most of the companies. And in that arbitration clause, the matter is now referred to an arbitrator who will hear the facts and the circumstances and will pass an appropriate award. So that is a dispute resolution. Apart from that, there is jurisdiction and governing law. Jurisdiction and governing law is basically when there is a litigation taking place which is arising out of this contract. So to illustrate further, I'll just say that, for an example, if there is a breach of confidential information, then the company employer feels that the employee has to pay damages to the extent of 1 lakh rupees or 10 lakh rupees. So, and the employee, when demanded, is not complying with the said demand, then they will subject this matter, this whole dispute, before some court of law. So this is the jurisdiction aspect comes. So we will determine, for the sake of clarity, that this particular court in this city will be having absolute jurisdiction to try any dispute which is arising out of this agreement. So then there is a clarity that there is this court will be, in event of any dispute, we will directly refer to this court. So that is why jurisdiction clause is required. Next is governing law. Why governing law is important is when we interpret an agreement, when a matter goes to this court, a court is looking into the clauses of this agreement, how much he should get paid, what should be the leave, what should be the working hours, is he entitled to overtime pay. These all depend from state to state. So every state has its own Shops and Commercial Establishment Act, which governs all these terms. So today in Bangalore, if there is any dispute happening, so I will refer to Karnataka's Commercial State Establishment Act. So for that purpose, we'll say that the governing law will be the laws of India and the state of Karnataka. It will help give a clarity that, okay, we have to refer to the local laws that is here, which is applicable in Karnataka, in order to interpret the terms of this agreement. Now, lastly, I think this is one of the most vital clause, in my opinion, is a restrictive clause. A restrictive clause can be of two types. Actually, there are many types, but I'll broadly explain you the major two types. These restrictive clause can be of type one is a non-compete clause and a non-solicitation clause. What is a non-compete clause? Non-compete clause says that during the term of this employment, an employee is not, that such particular employee is restricted not to work for any other organization. But there is also this survive termination. It also says that even after this term is over, the employee is not supposed to work in any company which will be detrimental to the interest of this current organization. So what does this mean? For example, this particular employee who the employer is hiring is developing a certain skill set, or is subjected to certain trade secret of the company, which if he leaves or he discloses after leaving, if he discloses after leaving, then it might cause a loss of business, because he's subjected to client list. He knows who the employees, other employees are, who are, what is the budget of the company, what is the projects they are supposed to get. All these information are privy to your organization. But if this employee leaves and joins some other organization and discloses this information, then it will cause it a huge loss to this ex-employer, right? So in order to protect that, we keep a restricted clause. Here there is a big take here. Any restrictive clause cannot be absolute in nature. So if you, so suppose you're hiring a software developer, I can't restrict the software developer to to not to work in any software company in future. I cannot do that. That is an absolute restriction. It is void also. It will render the whole contract as void if I include that particular term. But what I can say is here that if you are going to any future whatever organization you are joining, you are not supposed to do any activity which is detrimental to the interest of this current organization. So this will protect the company from any future risk after he leaves the company. The next is non-solicitation. Non-solicitation means, like today, if this company, this employee leaves the company, and later in future organization, if he sets up his own company or he joins any other company of similar nature, this clause will restrict him not to poach the current employees or the clients or customers of the current organization. It will protect in that scenario. So non-solicitation and non-compete are two restrictive clauses, which is a must-have. So I have just explained the major ingredients of a employment agreement, which everyone should consider while hiring your first employee. So let's protect the document from the very first stage, so that later, whenever any dispute happens, we need not have to bang our heads or have to, have to go through the trouble later on in interpreting, in determining the terms. So it should be clearly laid down as per the employment agreement, be it a non-disclosure agreement or a restrictive agreement. So this is it from an employment agreement point of view. Aakash will explain you on the points of background check, on the applicable laws, and also with respect to statutory compliances. Aakash.
Right. First of all, a very good evening to all of you who have joined us here today. Now, I will try to keep it as short as possible so that it does not end up being a monologue throughout, and we can have a little bit of question answers towards the end. So I'll start by talking about payroll and statutory compliances. Now, when I refer to the term payroll, what I essentially mean is all the employees who you have signed a contract with, and who, as a result of signing that contract, you're supposed to remunerate accordingly. Now, it is advisable that every organization has something of a payroll software that can effectively determine how long the employee has worked for and how much of remuneration he is entitled to. There should be a payroll department specifically in this regard who can ensure that disbursement of funds happen in an effective manner without any hindrances. And I will now explain the components of a payroll. So when you have an employee on board, it is important to remunerate him in an efficient manner and by following the trends which most of the other organizations are following. Because at this point, you want to incentivize the employee so that the efficient ones stick to your firm, right? So you offer him a gross wages. Now, gross wages, although for a startup, for the first employee that you're hiring, it is not mandatory, but it is advisable that you offer, apart from the basic salary, certain incentives such as dearness allowance, house rent allowance, then a certain bonus if the employee is performing efficiently. From this, you can make certain deductions as well, which you can pay towards your statutory obligations in the nature of employee provident fund or employee social insurance. But however, these things will come into picture only when you have like 20 employees. So it will be mandated by the statute then. As of now, when you're hiring your first employee, although it might not be a mandate on you, it will still go a long way in ensuring that the efficient employees stick to the organization. At the same time, with whatever you're paying your employee, you can make certain deductions even apart from these, which can be in the nature of some borrowing that the employee must have done from the firm. So all these things, after deducting from the basic salary that you are offering to your employee, you come to something which is called as a tax withholding amount. So from this amount, you are obligated to deduct tax at source, which we often refer to as TDS. And after deducting tax, then you pay your employee what we call the net salary of the employee. Now, when we talk about statutory compliances in this regard, mostly we think of labor legislations. To make it simple, we can categorize labor legislations into 4 parts. First is wages part. Second is social security part. Third is labor legislations that are specifically dedicated for women. And fourth is disputes part. Now, at this stage, we are not really concerned with disputes part, which mainly comprises Industrial Disputes Act, Factories Act. At this stage, for the purpose of our scrutiny, we will be looking at wages and social security. Although social security also comes into place properly only once you have 20 employees. So to start off, we will be looking at the wages aspect, where we have to ensure that we are paying the employees in accordance with Payment of Wages Act, Minimum Wages Act, and Payment of Bonus Act. Now, Payment of Bonus Act also comes into operation only when you are paying your employee at a salary of 24,000 or lesser. The main purpose of these acts is to ensure timely payment of the compensation of the remuneration to the employees, and to ensure that minimum standards of wages as set by the central government is followed by different states as well. The main legislation which we are concerned with at this point when we are going ahead and hiring our first employee is Shops and Commercial Establishment Act. Now, the definition of Commercial Establishment Act, the definition of commercial establishments in the said act is extremely wide, and it can include any organization functioning under the sun. And it is this act that regulates conditions of service, which includes hours of work, payment of wages, overtime, leave, holiday, and certain other conditions. Now, it is advisable that as soon as you commence your operation, you obtain a registration under this act from the concerned department within 30 days. After having done so, you get multiple benefits like opening a current account as well in the name of your organization. So it is extremely important once you have an employment agreement in place and once you take your first employee on board that you are satisfying these criteria so as to avoid any sort of a penalty later on. However, the compliances does not end right here. This entire process is so diverse in nature that we have to ensure that we are complying with certain other laws which are not strictly confined to labor legislations as well. To give you an idea, it is essential for us to comply with Information Technology Act as well. And this comes into play when we are doing background check of the employee before hiring. And this is where it becomes extremely crucial, because you want to be extremely careful about the kind of personnel you are having on board, because also of the concept of vicarious liability, which I'll be discussing in around 2 minutes time. When we talk about background check, it is essential to ensure that we have certain parameters in place that we have scrutinized the applicant on. It is extremely important to verify whether the educational details which are submitted by the applicant are correct or not, whether the address mentioned is correct or not. It is also important to go through the criminal history of the applicant, if any. At the same time, go through the medical history and see if there's any past of substance abuse. So for this entire process, which can be quite exhaustive in nature, one can either do it by himself, or there are a lot of third-party agencies that perform this task to perfection. And they will perform this task and submit a report which will be sent to the company, and the company, after scrutinizing the same, can make a decision on whether to hire that first employee or not. Because being very careful of this fact goes a long way when we particularly talk about vicarious liability. Because the concept of vicarious liability flows from the doctrine of respondeat superior, which essentially postulates that for any act of the employee, an employer should be held liable, because the employer not only owes a duty of care towards the employee, but is also in a superior position, so to say. Now, when we talk about this, there are two essential elements which we have to keep in mind. One is whether the person who is acting on our behalf is our employee or not. And this is as simple as it might sound. This is an extremely commercial, extremely complex aspect, because often there is a lot of resemblance in the nature of work performed by an employee and an independent contractor. And it is there that the employment agreement comes into play. The nature of work, as Ankita ma'am rightly pointed out, is extremely important to be clearly highlighted in the employment agreement, because come any dispute tomorrow, we fall back on this to see, to verify whether the person who's performing the work on our behalf is actually our employee or just an independent contractor. Because if he is our employee, then our liabilities are much greater. If he is an independent contractor, then we can do away with certain liabilities. Now, at this stage, it is very important to mention that despite an employer and an employee signing an agreement to that behalf, that there exists no employment relationship between us, that alone will not suffice. If the nature of the work that is essentially being performed by the employee of the nature that an employee otherwise other than the agreement is ideally supposed to perform. That's why it's very crucial to highlight the nature of work, the job description of the employee properly in the employment agreement. Now, again, it is in this context, it is very important to mention the need for background check. Because if you do not do background check sufficiently and you go ahead and do something what we often call as negligent hiring, then the liability that can be imposed on the employer will be much greater. To give you a very simple example, suppose you hire an employee whose job description mandates him to travel to some other part of the country or some other part of the state, whatever it may be, and deliver a consignment, something as simple as that. And he meets with an accident over there because of the fact that he was driving under influence. After carefully going through the records, the police department finds that he has been convicted of this offense 5 times in the past. Now, this reflects a negligent hiring on your part if you still go ahead and hire him for that particular role. This is where background check comes into play, and it is crucial to ensure that people with a history of that sort are not given the same roles in the organization, so as to shrug off any liability that might accrue to us in future. At this juncture, it is also important to highlight that when you are going ahead and hiring, say, your first woman employee, it is extremely crucial to educate her about the existence of Prevention of Sexual Harassment at Workplace Act, as per which she is supposed to know about certain measures that an organization is supposed to have at the workplace for escalating the grievances. And after having dealt with the statutory liability aspect, I'll just take 2 minutes and I'll sum up the kind of employees that you might want to have on board in the beginning, and the kind of employees that you can do away with rather than keeping them on board in the beginning. So not just for the purpose of cost cutting, but also for shrugging off certain liability and keeping the liability to at a low level as possible. Now, as a thumb rule, you should hire anybody who's critical to the success of your business. And I'm sure as entrepreneurs, you will understand it the way I'm saying it. However, at the same time, it is important to have at least 3 to 4 crucial, it is important to fill 3 to 4 crucial positions, so that the organization flows in a structured manner. I'm sure if you're the CEO of your company, and if you have the vision of making strategical decisions in future, then you might as well want to have something called as a COO, something who can operate your business on a daily basis. At the same time, it becomes important to have a product manager in place. This ensures that you're not working in the business, but on the business. This gives you the leverage to make those strategic decisions when you're not so focused on working in the business. And at the same time, the product manager will understand the need of the market and can create a product effectively for that purpose. You can also have a sales manager initially who can ensure that there's steady flow of income to the company. At the same time, there are certain positions that you might not want to fill in the beginning, which are of the nature of, say, a financial advisor or a legal advisor or a content developer. All these positions can easily be outsourced, and there is no requirement to fill such positions in the beginning. Now, I've almost come to end of my part of the session. I will just summarize by mentioning few general compliances which you should be aware of once you've made your first hire. So after having that first employee on board, you should ensure to be in conformity with Shops and Establishments Act, that by no means are you forcing the employee to work for more than 9 hours a day. If you are, then you should compensate him for the overtime done by him at the rate of twice the normal wages. A lot of organizations actually don't go ahead and do this, and this area remains quite unchecked, but it is still advisable to be in clear waters. Now, you should ideally give a paid holiday of around 15 days. Again, like it's a state legislation, every state will have its own particular requirement. But if we compare, then on an average, we can say that every state gives around 10 days of paid holiday and 10 days of sick leave. And finally, to ensure that in case there is any dispute happening within the organization or after you've made your first hire, it is very important to have rules of natural justice in place. The requirement of having a internal grievance committee will come into place only once you have 20 employees. But even then, even before you've reached that stage, it is extremely crucial that you follow rules of natural justice and that you don't condemn anybody unheard. Yeah, that will be it by my side. And if there are any questions, we'll be glad to take.
We should explain the work from home. If
yeah, right. Coming to work from home, as such, there are no rules and regulations that clearly govern on how you are supposed to go ahead with the work from home policy. But it is just advisable that every company should have its own work from home policy where you streamline the way in which all your employees are supposed to function, so as to in general increase the efficiency of the organization. Although there exists no particular law as such on this regard addressing this particular issue, it is still advisable that you still comply with the rules that otherwise exist for on-site working. By that, I mean that you still should not force your employee to work all throughout the night merely because they are sitting at home and working, right? And in case they do that, then you should still go ahead and pay them overtime wages. However, the main issue that what we see is that need is felt by most organizations is to ensure that there is confidential information that is being maintained even while employees work from home. And it gets quite tricky because when people come to an organization and work, they are given their own system on which they are supposed to operate, and they have their all they have their security measures in place, which might not exist when people are working on their individual laptops. So we understand that confidentiality is a huge issue, something that needs to be addressed. In this part, what our suggestion will be that you prompt your employees to use more and more such softwares, be it instant messaging apps, be it video conferencing apps, which are end-to-end encrypted. Because when these apps are end-to-end encrypted, it prevents the risk of hacking. At the same time, you can also have something called as a VPN in place, which is a virtual private network, so that even when people are accessing a public Wi-Fi, it ensures that confidential information cannot be leaked to a third party. So as long as you have these measures in place and you draft a particular work from home policy which highlights the need for employees to work from home, especially those employees who do not have to deal with clients physically, then it's a good way to move forward.
Yeah, I just there's one question I have seen. It's about is the Ministry of Labor and Employment advisory regarding the termination of employee for the job and reduction in wages binding on the companies? Yes, actually any notification, circulars, mandates passed by any Ministry of Labor Employment advisory, it's in government, is applicable and binding on the companies. But the companies have their own rules and policies, like be it code of conduct, HR policy, most of the companies do have, which should conform with the notification which are being issued by the Labor Ministry. So yes, all this all the notifications and circulars issued by the ministry are binding in nature.
So to continue, hope that answered your question, Ankit. If you want, you can unmute yourself and ask further. Okay, so firstly, thanks a lot, Ankita and Aakash. This was very, very helpful, and helped us all go through the basics of knowing all there is to know about hiring our first employees. Now, I had a few questions, which and anyone is open to ask any questions. Please feel free to write in the chat, unmute, or raise your hands. And meanwhile, I will ask some questions. Santosh, do you have a question?
Yeah, I have one question.
Yes.
In any private limited company, does there any fixed count or minimum or maximum where company needs to provide PF and HRA, medical, everything to their employees?
Private limited companies, actually what Aakash had pointed out, these actually for all the companies having minimum of 20, I think a recent amendment has come which states 10 employees minimum is required. In order to comply, you have to make PF registration and all. Post that, you can do the compliance like making PF contribution, creating accounts for your employee under the PF with the PF department and all. So there is a threshold number. So with respect to first employee, there are very few compliances. What Aakash has pointed out is that with respect to Shops and Commercial Establishment Act, there is a registration requirement, but with respect to PF and other Social Security Acts, there is no compliance with respect to the first employee.
At this stage, there is no such compliance of that sort that is required. It's just a way of incentivizing the employee.
Okay, then if there is no such compliance, then what should we commit to any first or second employee regarding their HRA and everything? If they are asking that what will be given by company to them.
Yeah, that should be your
Internal.
That is company's internal policy. That what you are formulating, how much salary, the quantum of salary which you are giving, you have to. It's company's internal decision to make. But yes, what he had pointed out rightly is your salary should not be less than the minimum wage which has been stated. It should conform to that particular notification because minimum wage is varying from state to state. So in whichever state you are, you have to confirm what is the nature of work this first employee is performing or the initial employees are performing, and you have to confirm with that requirement. And yes, there are HRA component, there are other dearness allowance and all those other component, which is a company's internal, it's up to the discretion of the company to take.
What a lot of companies do is rather than giving, say, a high structure, high amount, they keep the amount at a lower level, but they give incentives in form of these so that, you know, employees can claim tax.
Yeah, basic salaries are kept low so that.
So it's the way they operate. Either you keep the salary high or low, and then you give incentives, whichever way the company feels comfortable.
No. Why I am asking this now? Because if you are hiring someone, some very key person who would be very key person for our company for particular task, and if you are supposed to provide him appointment letter, then we have to at least mention these things in appointment letter.
Yes, obviously, you have to. That's what I said, that components of compensation, when whatever the salary you are providing, the components have to be clearly stated. In fact, there you can, in fact, after mentioning what are the components, like for example, you are providing HRA, you are providing other bonuses or performance related pay, all those, after all those kind of components, mentioning all those components, you can also mention that no other compensation are to be paid. Like this is it. Like this is the whole thing, and there are no additional compensation to be awarded.
Okay, thank you.
Yeah, I have received
Thanks.
more queries. Can we have 7 days work week at our company? Are there any government regulation? No, actually, Aakash, I think you can explain this, but I'll just quickly give you one short glimpse of this. For this particular query, you have to refer to this act, Shops and Commercial Establishment Act, which actually state, again, I said you that every state have a different Shops and Commercial Establishment Act and rules, which more states that 6 days should be working, 1 weekly off should be given. Okay, and Aakash, I think
I was going to say exactly the same.
Yeah.
It's mandated by Shops and Commercial Establishment Act, so you're better off not having 7 days work week at your company.
So 1 week you have to check which state you are working in, the exact what is the Shops and Commercial Establishment Act you have to refer to, and see what is the provision for weekly off. I feel every state has 1 weekly off.
Okay, thank you.
There's another question on differences of employees and contractors in terms of compliance and the level of responsibility the company can expect and force upon contractors. Right. So to answer this, employers in general are not liable towards independent contractors, and that is why it is extremely crucial to demarcate based on the scope of work whether the person performing work for you is an employee or an independent contractor. you are liable towards independent contractors only where the work involves an inherently dangerous activity. Now, this may vary from task to task, and it will eventually be left upon court's discretion to determine what activity amounts to an inherently dangerous activity and which does. In general, towards employees, you are liable even for minor accidents, anything that might arise out of a reasonable expectancy owing to the employment. For example, you are sending your employee to another state to give some document. I mean, she took a detour on the way, and she went to a restaurant, and in the restaurant, in the parking lot, she ends up meeting with an accident. As an employer, you are liable for that as well through the vicarious liability concept. But if it's an independent contractor, you won't be liable for it because it's not an inherently dangerous activity.
Hope that answered your question, Aditya. Do we have any other questions? You can raise your hand or write in the chat. Meanwhile,
I have one.
yeah, Santosh, please.
I have one question. The term e-shops, ESOP,
Yes.
is it advisable or not advisable for a company, for any employee?
E-shops is basically a incentive method which the company adopts, where company and it is actually encouraging your employees to entitling them for some shares in the company. So it is not advisable at the initial stage, but yes, at a later stage, you can obviously keep such incentive plans, like issuing of e-shop. It is an incentive plan basically. It is totally up to the discretion. But at an initial stage, I would not recommend to have an e-shop.
Unless and until you're facing some crash crunch, then in that way, it can ensure to have some liquidity in your organization.
Basically, it is used for retention of any important employee. I think so.
Yes,
Okay.
exactly.
Thank you.
Any other questions? So I wanted to check, and this is a very common question, about the any compliances when it comes to startups hiring interns, because we've seen many startup founders that are operating on lean teams, just the co-founders, and they end up hiring a lot of interns. And two things I'd like to ask. One is that if these are paid interns, what are the compliances that startups should be looking at? And most importantly, these are unpaid interns, because I've also seen examples of startups that take up unpaid interns in bulk numbers just to take care of few very outsourceable tasks. So anything they should be taking care of before making this decision?
No, internship, as with respect to internship related legislation, we don't have any such. There are few acts, but those does not really involve any private companies. So with respect to internship, it is totally being paid, unpaid. If paid, what are the compliances? What should be the parameters of pay? These are all, because these are not a permanent. So this intern does not fall under the category of an employee, right?
Okay.
In order to determine a wage for the purpose of minimum wage, or in order to determine any dispute under Industrial Disputes Act, it does not fall under the definition of an employee or a workman. So once in the event when they are not being categorized as an employee or workman for the purpose of this act, there is no such compliance involved keeping an intern.
Okay. Even if the intern is unpaid, so there are no compliances.
No compliance, because they are not an employee.
Yeah.
When once they become an employee, then the compliances creeps in. But when they are not an employee, then the compliances are not applicable.
Okay. And so Aakash was also talking about the importance of due diligence or background checks for the for any new hires. So for very early stage startups, what steps would you recommend they can take for this reference check? If they're doing it by themselves, or would you recommend that they engage some third party to do this?
Actually, doing it by oneself is quite a tedious process. It is best advisable to have a third party in place who undertake specialization in this particular aspect, because to have access to criminal records, there is no online database where you can check all of these things.
Yeah.
So it has a lot of it involves your physical activity. So it is best that you hire a third party who will prepare a report after making that inquiry and then send it to you. And based on that report, it is very easy for you to then decide whether to hire that employee.
Okay. And as you said, so for instance, if this, a startup did not do this due background or reference check of a particular employee, and that employee ends up being, somebody who has been convicted in the past, and they take up some action in the future. So can the founders of the startup be held liable for any of those acts?
Not generally, not depends on, again, what exactly is the wrong committed by the employee. Like I explained, if
Yeah.
can clearly if you can clearly point out that this was a case of negligent hiring. I example earlier of a driving under influence, how
Yeah.
a person convicted twice, and then again after being employed in a particular organization he committed the same act. So in such cases there can be statutory sanctions on the employers at times. Unless and until it's a proven case of negligent hiring, generally there's no sanction.
Okay, noted. So any other questions anyone in the audience would like to ask related to hiring and what we discussed today? Okay, and one final question that I'd like to ask. So as we discussed, Santosh also asked. Yeah, Aditya, you're raising your hand. You can unmute.
So, hi. There was this follow-up question that I had where we have been hearing of a lot of cases where employees who were removed a few years prior to the time, as current timeline, and they have been litigating about unequal gender pay. So, how do you recommend we handle something like that if the case is not something um, that are actually there, but it's being brought upon after a few years of the fact that the employee left or was fired from the company?
Just one second.
How do we establish that when we are paying and when we are paying anybody on ourselves and establishing their compensation, then we can ensure that this does not creep up any time later, or we do not do it negligently either? How do we handle that?
So I mean, first of all, an orientation session in the beginning should suffice, explaining what every person's role and responsibilities are going to be, and what the pay structure is going to be pertaining to that role and responsibility. So obviously you have to ensure that a male candidate and a female candidate doing same roles and responsibilities are not being paid differently. So as long as employees in your organization are clear as regards what their roles and responsibilities are, as opposed to what the person next to them is doing, then they will have a better sense of satisfaction that they are not being given unfair payment with regards to that.
Right. I had a previous experience at a company that I was working with, and there we were not even supposed to, disclose the amount that we were being paid to anybody else in the organization. Right. At the same time, there are organizations which have a very flat paying tier, like particularly by Peter Thiel. So in all his companies, he has a very flat payment tier for all the employees on that level, that everybody who's working on this product gets paid the same. And it's pretty much well known throughout the organization. So are there any laws that are governing this, or it's up to the discretion of the employer to decide? And when we do this, we also have to ensure that everybody knows what everybody is being paid, or just what the responsibilities are. Then there is a caveat to this which concerns me the most, is when people are passed up for promotions is the time where most of these are brought up to the front. So I ideally would like to prevent it by ensuring that everybody has a very fair review of their work and has very particular KPIs and KPAs to address, and based on that we can maybe publish it company wide. But I was also told that there are some countries which prohibit the objective evaluation and publication of that evaluation publicly to the entire company, because that might cause undue stress to some employees.
Okay, so basically there, as you said, that is there any specific law in India that governs that? There is no law which will restrict you from disclosing this uh, particular information with other employee, or keep it a transparent information available to all the employees. It's totally up to the organization. I think any organization should act in good faith here, like keeping what Akash said, that let's have like whatever the orientation process. We are not here to disclose the pay structure here, but we'll just keep it an like as a good practice. We will like whosoever is performing a set job role will be paid in that particular pattern, or the uh, performance related pay. We generally keep a performance related pay, keeping a basic pay, and then we'll attach a component called, if you perform or achieve this target or whatever the target specific, you will be entitled to this amount of incentive, bonus, and all those components. So I think these are all up to the good practice and of the company. Rest, there is, if you're concerned about any particular act or statute in place in India, there is no such which regulates it.
There is nothing, like my ma'am said, there is nothing which mandates you to disclose what the person next to the one employee is getting paid. But as long as you are in compliance of Equal Remuneration Act, which is a labor legislation in India, which ensures that people, at the same level of organization performing similar kind of functions are being paid in a similar manner. As long as you on your end are have done that bit, then there is nothing much to worry about. Now, if people are who did not get promotion and are coming and filing a complaint to that regard, then there is not much at that stage which you can do to prevent it, because some people might just do it out of spite. But once you have ensured that people who are performing the same kind of work are being paid in the same or similar manner, then the labor department, once it performs that check, it won't find an objectionable case in that regard.
Okay, great. Thank you.
Okay, with this last
Man, I think your audio went out. Can you repeat? Yeah, so I believe what Man was saying is that with that last question, we
yeah
can wrap up today's session. Thank you so much for joining us and enlightening us with this very, very crucial topic. And we look forward to hosting you again in the future as well.
Sure. It was a pleasure for us too. Thank you so much for having us.
Thank you so much.
Thank you. Bye.